I am John, the engineer Turmel, my symbol in politics, Guinness record. I'm running in my 91st election right now in Ottawa, Vanier, and I got to speak about marijuana last night. Last question, and they're all talking about got to protect the kids. And I said, whoa, whoa, whoa. First of all, bookies have spoken. The insurance companies in the U.S. have found that high drivers have less accidents. And that means they've got to come up with a designated high driver program to protect the kids by keeping the drunks and the straights off the roads. Number two, I'm talking about, hey, lady, you want to give your kids Ritalin and Prozac or a marijuana muffin? What's safer? And finally, I said, didn't you hear University of Saskatchewan in 2005 found that marijuana promotes neurogenesis, new brain cells? That's why I'm so sharp and they're so dull. And it always gets a great laugh with the dull candidates, they really are. So yes, marijuana is a big issue in my career. And in 2000, I came back, started the fight. I had always fought interest-free banking. And in 2000, my brother got busted, and I had to come back and start defending him because I'd been a guerrilla lawyer in the courts previous to that, having run underground casinos and defended myself each time I got busted. So I learned how to use the law, criminal law, and fight back. So when my brother was busted, he said, geez, you went to the United Nations, got to speak about your time bank money. Where else can you go? Time to come back and fight to legalize marijuana, which is also on my political program. You know, get cops out of gambling, sex, drugs, and rock and roll. So I said, okay, and within 1 week, I filed a federal court motion for Jean-Charles Parizeau, Canada's first exemptee, complaining about the limit of 3 plants. 3 plants, imagine, that's how many plants Health Canada gave a guy, not worried about spider mites. So anyway, within a year, I had 11 guys in court, federal court. All together, they opened up the Supreme Court of Canada building. You can read about those adventures in Cannabis Culture magazine back in those years. But after my brother was busted, Parker happened. And that's the big decision in 2000, which said that to have a valid prohibition and to bust the healthy people, you got to have a medical exemption for people like epileptic Terry Parker, who's going to die without it. That's the Parker decision. Prohibition invalid, absent an exemption. So if you got a bad exemption, no prohibition. Now what happened was they designed the exemption in such a way that people could hardly grow. They set 1 patient per grower. Well, how many DGs are you going to find want to do 1 guy for 15 plants? And 3 growers per garden. You know, I mean, big barn, 3 guys. Give me a break. You can have 15 in there. So they made a motion and said that, wow, that's uneconomical, and that makes the exemption no good. And the court agreed in Hitzig and struck down those caps and said, while it was no good, the law was dead. JP, a kid, was charged, those were his initials, and we're analogous to JP now because JP was charged and he made the motion, hey, if the exemption didn't work, Parker said the prohibition's invalid. I want my charge quashed. And his first judge said, you're right, quashed. Then it got appealed to the Superior Court. And Justice Rogan said, you're right, quashed, bad exemption, no offense. Then they dropped all the charges across Ontario that summer. Then finally it gets to the Court of Appeal with 3 judges. And they said, we agree, bad exemption, no offense, quash those charges. And then 2 months later, the government dropped the remaining 4,000 possession charges. And I got the headline at my site. I filed the appeal that did that won that. That was my appeal, me and Terry Parker. So remember Terry Parker? Anyway, he never got an exemption, so he kept complaining, saying, hey, if I, the poster boy, didn't get an exemption, the regime didn't work, did it? Which means the law's dead for everybody because they only had a year to do that. So, now that's what happened. In 2003, the exemption was proven faulty, and that's when the JP decision said your charges are quashed. And then the government dropped the last 4,000 charges. Now the boys in Montreal, Max and Martin and Eric, are going in with a quash motion just like JP. But they're not saying the Hitzig decision said there was a bad exemption because of the limits on growers and patients. No. The Smith decision in 2015 said that there was a bad exemption because you weren't letting them use oil. And you can't put dried bud on a tumor. You need oil. So, what is the worst exemption? Where they ban the proper use of the medication? Or they cut back on production? Well, we find that the 2015 bad exemption was worse than the one that got the law killed in '03. So, we have a quash motion coming up, which is before the trial starts, saying, whoa, 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 there's something wrong with this indictment. This charge of cultivation of marijuana, this should be dead because the exemption wasn't working when I was charged, said the Supreme Court in Smith. That is their motion to quash their charges before they even have to plead. I say, it looks like the law is dead. What do you say, Your Honor? And if the judge says, no, I think it's still alive, and they will. I failed to see whatever you said, therefore I disagree. Now starts a trial. And there's a plea, and now starts a voir dire, a hearing within the trial, a constitutional challenge. Now, this is the constitutional challenge. This is like doing what Parker did, saying, hey, the prohibitions are hurting me without a regime. These are the pains I'm suffering. Therefore, I need these prohibitions struck because there's no exemption to save me. Then he said, with an exemption, you're okay. But then we're saying here the exemption ain't working. So the judge said it is. We therefore now have to do a motion to strike down the regime as unworkable. We have to now reprove it again. We have to show that the regime didn't work in order to trigger the Parker no prohibition if there's a bad exemption. Now, the analogy we have supporting our case is the famous Murdoch case out of St. Catharines 4 or 5 years ago. You'll remember that one. He had his witnesses testify, all these doctors said no, they wouldn't give us our marijuana, they didn't do it. So the judge ruled, whoa, with 90% of the doctors not signing, that means that this exemption is illusory, it's not really helping anybody, and therefore I'm following Parker. If I'm striking down the exemption as unworkable because the doctors ain't there, and how can it be workable if the doctors ain't there and they're supposed to be, then I have to strike down the prohibitions on possession and cultivation of marijuana in the CDSA. He followed Parker. So far, we had the Parker court, 3 judges who said you got to have an exemption, we'll give you a year to come up with it. Then you had the JP court, first guy said, hey, bad exemption, no offense. Then the Superior 1 judge, bad exemption, no offense. Then the 3 more Court of Appeal judge said, bad exemption, quash the charges, no offense. So that is now 3 and 5. So there's 8 judges from the past who said that a bad exemption is no offense. Now, since then, we've had judges who struck down the exemption but didn't strike down the prohibitions, didn't follow Parker. As a matter of fact, there are now more judges who didn't do it than who did do it. And the Crown now comes to court and says, look at all these cases where the judges said that you can have a bad exemption but you can still have an offense after Parker, and try and reinterpret that. So, but we've got the first 8 in the Parker and the JP decision, and then the Murdoch decision with Justice Taliano, when he said, if I'm striking down the exemption because the doctors weren't there, I'm striking down the prohibitions, like Parker said. That's what we're now asking too. Now here's the point. When Alan Young went and originally asked the Hitzig case to strike down the exemption as bad, he didn't ask for Parker. He didn't ask to strike down the prohibition. And if JP hadn't asked, it wouldn't have been. Now, with the Svetkopoulos, once they put back the limit on patients to growers, Alan Young went and challenged it in federal court and got it declared an unreasonable limit again. And again he forgot to ask to strike the prohibition. Then the Barron case, they went and struck the limit of 3 gardeners again to 1 grow-op as unreasonable. And again they didn't bother asking to strike down the prohibition while the exemption was bad. Same thing with Allard. They won the exemption was bad, but they didn't ask to have the prohibition struck down. Now, we had a bunch of people in federal court, and we did. we asked for these flaws, including the Allard flaws, but we said if you're going to say the exemption's no good, we want the prohibition struck too. So the judge could duck that by saying they didn't ask. And the same thing with Smith. They got the exemption flaws struck down, and they didn't ask to have the prohibition struck down with it. Now, that's because they got lawyers. And what are these lawyers doing? Well, guess what? Remember how it works. If the exemption's busted, the law's off. Okay, John Law leaves us alone. Now, the lawyers are arguing the exemption's busted, and they're asking the courts to strike the flaws and fix it. And what happens when they fix it? They can argue the prohibition's back alive. So, on the very day in 2003 when the court admitted that the prohibition had been invalid since 2001 and they were going to drop 4,000 charges, is the same day Alan Young announced to the world that the court brought the law back to life by fixing the exemption. So when you hear lawyers talking about fixing the exemption to help the patients wouldn't need an exemption if they didn't fix the exemption. Because a busted exemption means a busted law. So what lunatic lawyer would want to go fix the flaw that's making the law be off? And he did. Twice. Now, same thing's happening now with the Allard case in 03 and 14. They announced we're cutting everybody's grow up, shutting them down, and suddenly the patients all saying, we want an extension of our exemption. Hey, if April 1st comes and there's only 6 LPs to handle 180,000 keys a year, the exemption is illusory and the law's dead. So Health Canada got some lawyers to sucker some people into financing a fight to get the exemptions extended, thereby extending the prohibitions for everybody else. Now, it was never explained to people that way, but that's reality. Forgetting all that, we had all these complaints we have against the MMAR and the ACCMQ and whatever in court, ready to go, and the judge stalled us saying we'll deal with the Allard problems first. And now that we dealt with those, your problems are all fixed. Oh yeah? Well, we're back in court bitching about them again. That's how much he didn't fix them. So, back to the boys in Montreal with the constitutional now. What kind of problems are we talking about? Well, the number one big one is the doctors. We want to have patients like Murnau who will come and say, my doctor said no. Nice guy, but he said, I haven't studied it, there's no literature, I don't want to be known as a pot doctor, my insurance company's going to give me hassle, I think, the Doctors Association doesn't want me to, understand? Non-medical reasons. Then the Court of Appeal can't say, oh, maybe they had a good reason. They didn't. We need patients to come to do what I call the Murnau plus Y motion. You come, you explain the doctor wouldn't sign, and why, the non-medical reason. And every doctor out of 35 million Canadians and 70,000 doctors, that's about 500 patients on average, and when a doctor throws you out of his office or says, I haven't studied it, sorry, you know he's not serving his other 500 patients either, is he? That's why the more of these we can file, whether or not they actually get to testify, we don't think the majority will. If we could get 1,000 people complaining about this in the next week or two, actually, if you get them in by next week, it's officially on the record. You're going to be in history. If it goes past next week, they might want to argue you can't, though technically you got 30 days before the hearing to keep doing stuff, and we will. But you want to get your will say testifying how the regime hurt you and let you down before the 7th. The instructions are all there. Now, the case is called, they will do Gauthier, because Maxime Gauthier is one of the guys busted, and there's Martin Gendron and Eric Gravel. And these 3 guys have all filed the required motions and gone through the proceedings. So, the trial opens, they're going to have the quash motion heard first, and then if goes past that plea, then the charter motion. Now here are the issues. Number 1, the doctor issue. A lot of people can testify about that. Number 2, no drug information number, which means that Maybe you had insurance and you could never get your marijuana covered because it had no drug information number. If so, if you got hurt because of that, now they got a drug information number. That pain is now gone. Well, if you suffered that pain in the past, tick it off, tell us. Number 3, require annual renewals. Now that just costs the people money. Over and over, and especially when they got permanent diseases. That just shows pure malevolence. And of course, it means a doctor has to fill out the same forms every year thereafter. So he can't just like deal with 5,000 patients over 10 years. 500 guys get their prescription and never come back because they're healed. He's got to deal with them every year. So he can't do 500 a year. Pretty soon he's doing 500 a year, 400 are regulars, and only 100 newbies. So it's a way of putting a damper on the number of doctors who can do it and turning them off by the paperwork. So now compel exemptees to destroy any surplus before receiving your next shipment. Imagine you have a good month, not much pain, you don't smoke too much, you got some left over, you're supposed to destroy it. The next month you're going to have a bad month, and you can't have any more until the end of the month. So if you didn't destroy it and you suffered the stress of committing a criminal act by not your surplus in case you ran short next month, tick it off. Tell the judge. Now, allow the ministry to revoke patient licenses for non-medical reasons. Our example, and I hope to have some witnesses from out east, are Dr. Cameron's, the guy from Cohill. You know about him? St. Cameron's went out to the East Coast and he signed up thousands of people. And then Health Canada announced that because he hadn't signed his permits in his office, but had signed those permits in the other provinces, that was a fraudulent and unacceptable activity, and they canceled 2,000 patients' exemptions in one shot. So, Health Canada bureaucrats cut off 2,000 of Dr. Cameron's patients over a non-medical reason. And I bet some were legitimately sick and suffered. And they failed to exempt patients from Section 5.1 trafficking offenses because, look, you need to test different strains for different pains. And it's illegal right now. And that's stupid right now. You can only go to the 1LP with their selection and that's it. Oh, they made all these talks about taking your strain and keeping them alive. Bull. Never worked. So Canada's probably lost half of all our strains, except for the growers who've stayed alive. Now, under the MMAR and the new ACCMPR, these are grower rules that are offensive. They prohibit more than 2 licenses per grower. How many DGs are going to take a guy with 15 plants? How many DGs are going to take a guy with 10 plants? 2 grams a day. They can't. If they got any kind of a decent sized operation, they're looking for bigger licenses to make use of their facilities. So, limiting the number of patients to the DG is as offensive 2 to 1 as the Svetkopoulos and Hitzig courts found 1 to 1. 2 to 1 ain't much better. Prohibit more than 4 licenses per site. Well, the Hitzig and the Barron Court found that 3 licenses per site were unacceptably, unconstitutionally violating their right to access to their supply, struck down the cap, and the government made it 4 a week later. Not much better, right? So again, we're saying that 4 is unconscionably almost as bad as 3 and not much better. Thank you that all those arguments about its unconstitutionality at the 3 level have already been made in those other cases, so we only have to point out how much better is 4. Not much. Oh, and you're not allowed any garden help. If you have to take care of your own spot, you're not allowed anybody to help you. Oh, they're thinking of you. The patients with the most dire need, no help allowed. Someone thought of that, a bureaucrat. And finally, to limit the number of plants. Now, my brother got busted. He had 4 pounds towards his 11. And he got busted for growing too many plants. Now, why would they want him to not grow as fast as he can up to his limit? Why would they want to keep him growing slow? Well, if he hit his limit, he could take 6 months off. He could take a year off. Why can't you bank 5 years worth and take a few years off? Because they want you stressed out doing it full time. They're malevolent. So, 5 plants also limits you to big plants. The patient's got to lug around big pots. Some people want to do a sea of green, a whole bunch of little mini plants. You know, bud on a stick. They don't want to do big plants. They can't move big plants. And that's what the limit does. No reason for big plants. So, those are the MMAR. And finally, no criminal record for 10 years in growing marijuana. No drug offenses, so you can't be a DG if you've got a criminal record within the last 10 years. What? You don't want to have the bikers go straight? Is that it? Why should... I hope a couple of bikers fill out the form and come tell the judge, Your Honor, we'd like to go straight. We used to be good at it. Never got in fights, you know. We're happy with it. Let us get into the business, please. So that's, again, what's the purpose of the 10 years? Except patients who got busted before they got their exemptions are going to have difficulty. And again, guys with experience are going to have difficulty. So, finally, MMPR and the ACCMPR. These were without the growers. Now, the licensed producer may cancel if there's reasonable grounds to believe that false information has been submitted. Like, for instance, Dr. Cameraman signed it in the wrong province. Now, the licensed producer may cancel if he believes. A, if the licensed producer believes, have him tell a cop. Okay? Then the cop will deal with it. It ain't up to the licensed producer to do the cop's job. So, cancel registration for an undefined business reason. Can you believe that? Geez, we didn't have a big enough crop, we're cutting your license. Sorry, bye. And guess what? Not allowed to return the medical document to the patient when they cancel you for a business reason. Who thinks this stuff up? They can cancel you for no reason, no good reason, and then they can't even give you back your medical document. Guess what? When you fax your document, your original, from your place to them, it becomes the original. Yours isn't anymore. If you send it in as a grow application, it gets rejected by Health Canada. Another 3-week delay glitch they've dreamed up. So, yeah, that is another one. They can cancel you, anyway, and you can't get it back. Now, I advise people who do get their signatures, ask the doctor for 2 or 3 originals with different ink. Because you never know when they're going to find a way to say one of the originals isn't good, and you'll have another one. And you'll have a different ink, because you might have to prove it's not the one with the blue. So, do that. Take the precaution. So, and then finally, the 150 gram limit. Now, in the Allard decision, where Health Canada won their cherished 5 gram a day limit times 30 days, 150 grams, we want everybody limited to. Even though some people got prescriptions for 300 grams. Tell me how you're going to ship at 150 a gram to a guy with 300 grams a day. 60 shipments a month per liter? And he can only possess 150, not even his whole daily dose at once. So, now most of these people want it for salads and stuff and compression down to hash oil. They're not all smoking 200 grams of bud, okay? Keep that right. So here's the point. In the decision, the Allard decision, you had Judge Manson in paragraph 55 who admits that the average prescribed consumption in Canada was 18 grams a day. The average prescribed. Then he points out a little later, Health Canada took some polls and their numbers came in between 1 and 3. Not 18, the real number. So, I, the judge, I'm going to believe the 1 and 3 estimates of the average and not the actual determined average. Judges, no good in math. Okay? So anyway, now, when they say the average is 1 to 3, did you learn that the average was 2? Did anybody ever give you an average that was a range? So when they say the average and they give you a range, you know they're fudging it because this number should be 2. So Now, I did a statistical analysis of the odds of them being so far off so regularly, and I went and studied them. And I was a teaching assistant of Canada's only Mathematics of Gambling course after a degree in systems engineering, and I've been accepted as an expert witness in the mathematics of gambling, including in Canada's tax court. So, when I say that this is a fraud, and the odds are 150,000 trillion billion to 1 against them getting 2, 3, let alone the original 1 way off there, it's like those are called outliers. When you're 5, 6, when you're 10 million to 1 off with one shot. When you get 2 guys 10 million to 1 off, and then 5 guys, everybody they say is 10 million to 1 off, you gotta multiply them all together and it becomes nuts. So I caught the government in a complete statistical fraud, which is the reason we can claim cash damages for having been shut down by the MMPR with our grow-ops. I got a damages suit up there in civil court, but the point is, the judges just condemned the MMPR and declared it unconstitutional. And that is the one that shut down your grow-op for no good reason. And you know why? Because they said that, hey, fires, danger from fires, we're concerned. Guess what? They were asked, how many fires were there? None. And danger from mold. Hey, do people who have grow-ops control their mold better than ordinary people or not? Guess what? How many people with grow-ops you think got mold? How many people with regular houses got mold? 90%. So we caught them on those lies, and finally the statistical fraud with the average 1 to 3 grams. That proves malice. You can't sue the government for damages from bad legislation. You have to show malice, error, and that kind of stuff. And that's what we have here. We have them lying about the mold, we have them lying about the danger of fires, and we have them lying about their surveys. So, there's a good reason for people to go claim the damages from shutting down my grow-up, and I had to go buy from and all that stuff, and I lost this and I lost that, my equipment's no good anymore. So, that's available too. Now, back to the thing, cancel that, the 150 grams. Now, of course, the best one is LP prices are unaffordable. If you can't afford to go to an LP, what are you going to do? You got to grow yourself. And so, with LP prices unaffordable, people who can't grow themselves are completely screwed. So, the LPs have not been a valid alternative, rather illusory. And what have they got? 30 guys out of 1,000 have managed to get through the red tape to get LP status? 30 out of 1,000 applicants? Boy, did Health Canada manage to do the red tape to drown that business, didn't they? So, finally, LPs cannot supply fresh leaves for juice or oil. Maybe oil now, but they can never do fresh leaves. And you want to have half a pound of fresh leaves a day, don't you? That's why you can ask your doctor for a half a pound a day prescription, 200-300 grams. You don't want it in bud, you want it in salad. Finally, Health Canada urges doctors to cut back their prescriptions to 5 grams. Have you heard about that? Have you heard about people's doctors being contacted by Health Canada to check their prescriptions? Especially if you got 45. They're going to call and say, did he add a 5 or did he add a 4? Did you only put 4? Did you only put 5? So, they were putting that kind of pressure on long ago, and I've been hearing about it again. So, non-instantaneous registration of grow licenses. You're pretty well instantaneously registered with your LP for a possess license and a smoke license right away. But a grow, that's going to take you weeks and months. Now, I know my brother is helping a lady, she's at 14 weeks right now. I had a guy on the internet said he's at 20 weeks waiting for a grow license, which should be instantaneous. Okay? Especially now. In the old days, they had to check all this and that and that. Now there's nothing to check anymore. The doctor signs that, it's an empty form. So, if it's not the length of time that to process the damn thing that's longer, what's longer? The pile that it's got to go through before getting to the top. That's what's taken 13 to 20 weeks. So it should be instantaneous, like the License Bureau and even the other parts of the health department. And no designated transformer. Guys who can do it safely should be able to transform it for you. And you should not be put in the risk of having to transform it yourself. And especially in the times of old when they only had butanes and those things there. Now you got dryer and other methods to do it more safely. Nevertheless, we need designated transformers. If we have the right to oil and juice and all these things, why don't we have a right to someone to do it? And last but not least, the prohibitions stifle hemp production. Now, hemp production is limited by the content of the THC. If it's 5% THC, how many people think the kids are going to be raiding that field to smoke it? 5%. What if it's 3%? The kid's going to be going smoking that 1%. Guess what? They only want you to use pot with under 0.3% THC as hemp. 1% stuff can't grow. 2%, 3%. Stuff nobody wants, you can't grow. You can't use. So, what a stupid limit, meant only to hamper the industry. So while wheat goes massively, millions of acres, hemp barely moves at all, and hemp is more nutritious than wheat. What can I say? So those are the 21 issues that we are raising to say that the exemption is unworkable. It can never be workable because these things can never all be covered. And even if Myrna won with only the doctors, the judge saying, hey, if doctors ain't signing it, don't work. Okay, he's right. But the point is, if people can't get it for other reasons, it doesn't work. So, especially waiting 14, 16, 18 weeks for your grow license and then another 5 months for your crop. What kind of smarts is that? So anyway, and you can't start till you get your license, and then guess what? Your license started when you applied, so now you're only going to last for another 7 months before you got to apply again. Go spend another $1,100. So anyway, that is the complaints. So, we're asking the judge to declare that the exemption regime under which they were charged at the time, and the current one, which is based on that other one that we're striking down, should all be struck down too. Which means that we're asking the judge to strike down the exemption and asking him to enforce Parker, like Judge Taliano did. And we're coming in here with something, the Myrna, that won all by itself, the doctors, and we got the right question. And letters from the Doctors Association of Quebec telling the doctors not to. What could be more cinch? The doctors are signing for non-medical, not signing for non-medical reasons. So, that's it. If they strikes that down, then we're asking them to expunge all the... Now this is back till 2001. This exemption's never been a din. Always been yearly renewals. Always needed a doctor when a doctor wouldn't sign. There was a time when there was one doctor in 100. Justice Letterman said, see, it works. Well, to a judge, 1 in 100 might be success, but not to a gambler. Anyway, so that's it. If the constitutional motion and the patient's testimony, as they tick off every one of the things until the judge says, okay, I had enough about the 5 plants. You wanted smaller ones to move around. I got that. No more guys talk about that. Until every issue is covered, including the guy who got dragged in until it took extra hours. Hey, you get arrested, they're going to hold you until they check with Health Canada. Guess how long it takes for Health Canada? Hours to answer, because there's no instantaneous database again for even the police to check. So we have a guy who got arrested, and then after an hour and a half they couldn't contact Health Canada, so they took him in custody, tried to get in contact with Health Canada. After a half an hour and a half they gave up. They charged him and took his pot, and then they gave it back to him the next week. So, those kind of inconveniences due to this stupid regime. But if the judge should say, still working, people can still get it, and enough people can get it, I think it's working for everybody. Judges can fail to see anything. That's what I call the insufficient evidence. Like, you could always listen to the news, they're always talking about no evidence of, no evidence of. Well, look at, the guy who ain't got his eyes open can say, I see no evidence, right? And that's exactly what goes on when they say no evidence. It's an out. So If he sees no evidence that these testimonies are valid and he doesn't think the MMAR is that bad and the law is alive, then the boys go to jury trial. Now, because they were smart over here, they're going to pick the jury after they find out if the constitutional wins or not. Then they're just going to admit all the facts and they're going to get their guilty verdict. Then they can appeal the quash and the constitutional issues to the next level. And then finally one more level after that. And they say it takes about 2.5 years to go through the Court of Appeal level and 6 more months to the top. So that there's a good chance that Parliament might do something to let everybody go before I can win it. But I like it. When I hear Justin Trudeau reneging and putting it off another 1.5 years, I'm going, that gives me another 1.5 years to win it before he can be forced to do it. But his father reneged the full 40 years. I don't see why Justin shouldn't be renegger too. That's it. So, if you guys now can help out, if you've suffered for these regimes, and you want to be in on this last famous case of an era attacking the regimes, well, just go to johnturmel.com/Gauthier.pdf. And that'll be the motion. You don't have to print it. But at the end of it, there's the 3 pages, which I also call witness.pdf. So, if you go to the johnturmel.com/witness.pdf page, print it out, tick off where you want to comment, and if you run out of space, just go to the back and put note number 1 for point number 1, note number 10 for point number 10, and just keep talking till you've said it all. And it's going to be entered into evidence officially for history. So, you got a sob story to tell? I want to hear it. Even if it's only in writing, it's going to get in if you get it to Max by the 7th. So the instructions, the phone numbers, the email address are all there. All you got to do is go to johnturmel.com/witness.pdf and you get all the ticks you need to be able to participate in the johnturmel.com/Gauthier.pdf motion. And of course there's a quash motion that isn't listed, but it's at my general page, johnturmel.com/kits. I have court kits, I call them, des formulaires, court kits for civil, for legal. You're in jail, I'll get you out pending appeal. You want to overturn an old conviction, I got a form there. So all sorts of forms I've developed over the years, but the important one right now is the current constitutional cause célèbre in Montreal with our Montreal Medpot Musketeers, the 3 who are coming up June the 20th. And if you get your will say in by the 7th, it's in for sure. And if you get it to them after the 7th, well, there's a good... Within 30 days, May the 20th, that would be still fightable to get it in. But it's guaranteed in by the 7th of April. And after that, we'll just put them in a book and submit them, see what happens. So it's going to be a wonderful, wonderful case, the culmination of years of work. 3 important motions, the quash motion and the charter motion. And then, of course, the trial is going to be a little blip of 25 minutes, like the case we had in Gatineau just last week or the week before, which said, un procès de 1500 secondes. A guy busted with 20-some plants, 22 plants. And he ended up saying, I need a jury trial. And they had to call 300 jurors to come and pick a pool of 12 with 2 alternates. That's like $45 for each one of them who came, then $100 a day for 3 days for the jurors after that, and then the judge, and then the 3 lawyers, and then the police witnesses, all for 22 plants and a suspended sentence, a year probation, and 100 hours community service. So, if everybody used my kit there to fight back, and then if the judge threw out the quash motions, I'm not reading it. And the judge threw out the charter motion, said the chances of survival got nothing to do with the right to life. You're not sick. Whoa! He's not here for the right to life. He's here for Nicholas. He's here for the right to liberty that's being violated. The 4,000 guys who got their charges dropped, they weren't sick. But their right to liberty would have been violated if they'd have been charged while the exemption wasn't working for the sick guys. So all we gotta do is prove the exemption ain't working for the sick guys, and we should get the same. That's what we're talking here. So the quash motion, and then if the judge insists, we'll try and kill it all over again. A la Murnau and more. And then finally, if he forces it through, then we take those issues to appeal, because we know the jury will find him guilty of having produced those plants in that place under their control. They're not going to lie. They're going to take the consequences and appeal. So that's where it is. This is going to be a cause célèbre in Montreal. June 20th to the 22nd is the start. And I'm sure everybody who gets in a will say is going to come and want to watch this one, especially in case you're called. So get your sob stories in, because they're valid. And if you don't get them in now, no one will ever know again. Oh, you can moan and carp all you want, but nothing feels better than making it official, getting it on record, going on attack, saying they did this to me that hurt me. So have a little catharsis. Get out there, feel good. Take a shot at the bad guys. Say your piece. It's free. Can't get hurt, and it'll feel good in the end, especially if it wins. You'll be in on the win, in on the kill, and this is it. So 3 Med Pot, Montreal Musketeers, June 20th starts the show. I hope you can be part of it.